Welcome to Beers with Contractors.
Tradies, another episode of Beers with Contractors, another Thursday. Hope you guys are doing well. Summer heat is coming, so I know you guys are firing up on all cylinders. Listen, I got to square with you. It's hard finding good help. We're going to talk about how I've hired Terry as my co-host and how that's going to work out today with our guest. But this individual, this person I have on the show today, I have been trying to get on here for months and months and months, and they are a rock star in the construction industry. And specifically because, number one, they're an expert in their field, but second, yes, they have actually a personality, which is amazing. And when we get down into the weeds, I know that you guys are going to start to think like, all right, what are we talking about today? And my team's good at putting a nice fancy thumbnail on there that makes me look like it's exciting. But I am passionate about this with a lot of you guys that are out there scaling your companies. You're grinding at it. You're running the 60-hour weeks. You're just day in, day out. And all of a sudden you turn around and realize there's a lot of key important things that you have totally missed. And this guest today has done a really good job of getting crayons out for me, because you guys know I'm a Neanderthal, all 5 or 6 of you listening. What I like about it is it's also helping so many of you home services companies out there, whether or not you're trying to scale or not, keep a line of sight on your employment compliance and everything around the largest group of people in your company, which is your employees. So our guest today is Tracy Melvin, the president, the CEO, the janitor. She does it all at Melvin Law, but she specializes in, she's an employment attorney. And I met this great person several months ago through a cohort of mine, Corey Parks. If you're out there listening, you know who you are. And I was blown away, and I was like, you have to get on our podcast. So welcome, Tracy, to Beers with Contractors. Cheers to you. Don't know if you're partaking today, but you're probably being compliant, which is a lot about what we're going to talk about.
Oh, wait
today,
a second.
Right?
I mean,
there we go.
Yeah.
That's what I'm saying. That's
it's a ranch water. It's not technically a beer, but it's close enough, right?
Yeah. That's perfect. Well, cheers to you, Tracy. Thank you. I know that there's tons of specializations for attorneys, and I'd like to hear a little bit of why you decided to specialize in employment law and things like that, because this is a niche that we find a lot of we do that, but it's not really our specialty. Or, it's one of the list of things that we can pull from our firm, but it's weak execution. So what made you gravitate towards this specialization?
Yeah, great question. So I would say I'm a little bit of a non-traditional attorney, and I started in HR. So I didn't leave undergrad and go right to law school. I took a little bit of time to figure out what I was going to do. And so entered HR, was an exec HR, and just loved and had a passion for making sure employees were taken care of, but employers were compliant. I think that employers got a really bad rap, right? The employer is always wrong. The employer is trying to take advantage of the employee. And I found that to be generally not true. And so I decided at one point in my career was a very supportive employer and very supportive mentor to go to law school. Because my experience was HR and my goal was to support employers and to have employers do the right thing, my focus was 100% in employment law. So I did go to Marquette in Wisconsin specifically for their employment law program. And ever since, all I've done is employer side representation. I'll do a little bit as to why construction. My whole background of family is construction. And so it's an area that
there's no escape, is it?
There isn't an escape. Yeah, my grandfather owned a concrete ready mix company. My dad was VP of a brick company. And so it's in my blood, I guess. And because I'm not, I guess, a typical attorney, I hope I can talk the language and speak with less legalese than some might. And so that really has made it easy to enter into that industry and bring my expertise and meet them where they're at as business owners so that they have a trusted legal advisor, not somebody that's, maybe just coming down with the hammer.
Now, I think we talked about this on one of our previous calls. Your family's still in the construction industry, right?
Yep.
Are you billing for your time there now? Or are they still hitting you up at Thanksgiving?
No, my friends and family in the industry may pay in food, sushi sometimes. So
Yeah.
yeah, but most of the time, if I'm providing proactive advice, to me, it's just the right thing. That's why I do things like this. Is if I can give little nuggets and it can help a business owner do the right thing and avoid a lawsuit, then you don't
No.
have to pay me.
Well, listen, out of our 5 to 6 listeners out there, like now that I know that you're toting around ranch water,
I know.
just know that Tracy does not accept payment in ranch water. But,
It's true.
I'm sure no matter what the fees are, the value, what I have experienced have far exceeded the benefits. And it's so cool because we work with a lot of similar people. But let's break this down kind of from the basics, because we all, as contractors, doesn't matter if you got 2 people or you got 100. What's the most common mistake specific to payroll that we're doing out there that we don't even realize that it's illegal? And we're just trying to pay our people. We're trying to just plug it into QuickBooks. Like, what is it?
Yeah, I'll first say, like I said, I don't think employers try to do the wrong thing. So it's interesting that when I talk about what is the most common, kind of wage and hour payroll mistake, it's generally not because an employer is trying to wrong someone, right? They're actually
Mhm.
trying to, do right by the employee or pay them the best they can. It's really actually hard to say one, but I would say not classifying an employee as employee, classifying them as an independent contractor is probably
Oh,
the number one, right? Because now you're paying them in a different mechanism. But outside of that, if we talk about employees, it would truly, not be calculating the regular rate correctly. And so maybe you're paying cash bonuses on the side and you're giving them a really hefty hourly rate because you just want to be like, you did a great job. Your truck was clean every single day. I'm going to throw you $100 at the end of the week. Well, all of a sudden, what seems really good because you've thrown them $100 on the other week, which they've never, they wouldn't have had otherwise. That $100 should have been calculated, and now their overtime for the week is wrong too. And now you have a legal exposure that you didn't even think you had because you were just giving the guy $100.
yeah. Well, and I think you're right. Most employers, they want to pay their people more or reward, and they don't realize that they're about to get slapped on the hand, And we talk about slapping on the hand. Let's just break that down. Well, where would one find a resource to say, hey, I need to go through a checklist here to figure out what am I doing wrong here?
I wish it was so easy, Will, right? Wouldn't that be
Uh-huh.
nice? Like a one size fits all. The government just handed you this
Oh,
beautiful
yeah,
checklist.
that's right. Yep. Mm-hmm.
That would be so nice. I might not have as much work to do, right? I think that the one thing the DOL does a really good job at as a federal level, I know we might talk about and touch on state stuff in a little bit too, but at a federal level, they provide actually these really easy to digest fact sheets. And so an employer, can just use the free resources that exist, right? And just make sure that their payroll practices are in line. But sometimes even the sophisticated HR professional can't figure out what that really means. Or maybe you know what it means and you know what to do, but your payroll system doesn't work and doesn't, actually allow you to do it. So it's really a collective, right? Using the DOL stuff, using a good lawyer to help with audits or resources. Your payroll vendor should be able to provide really good resources as well. I say that, however, I have a client right now that their payroll vendor is allowing them to not calculate something correctly. So, and they're kind of saying, oops, it just doesn't work like that. And, but I think that relying on the government resources, having good legal counsel is really important. Doing an audit and some checks and balances internally before you have an employee complain is really important.
Well, and I think that's probably, is that where most of this comes from, is meaning the problems associated with us as contractors. The spark that ignites the flame is typically the employee, right?
Typically, I would say there's a couple every year we'll see a little bit of a shift on whether, we're talking harassment discrimination, the EEOC is going to focus, DOL, where they're going to focus. We see a difference sometimes at a federal level and a state level, maybe a state's taking a specific focus. Say Illinois, for example, is taking a really big focus recently on the independent contractor, specifically in the construction industry. And so even in, enacting certain laws that are going to put some more protections on it. So the spark, a lot of times, yes, it could just be the disgruntled employee, or the spark could be an audit from a government agency that has taken a focus on this industry. This industry is unfortunately known for trying to avoid overtime laws and trying to misclassify workers. And so a lot of agencies, it will come directly from the agency, and it may be random. You think of your random OSHA audit, right? It could just be like, we're going to audit your books today because, and all of a sudden they uncover more. It could be an unemployment insurance audit that then leads to a wage and hour audit because the state keeps digging.
Well, it's so funny to you listeners out there. Love Tracy in her consistent and persistent requests for my questions for today's podcast. And now she's getting a deep dive into how I'm not even following my own questions.
I don't think it's on the list, but it's okay. I can still answer it. So this is good.
I know. And I know this about you. And that's what I love, because when I talk to some attorneys, it's kind of like, let me give you like a 10,000 macro view of it, soft politician answer, and you just dive right in. So to rewind on that, like, let's say I get a letter, or it's probably a letter, right? Saying, hey, we're the Department of Labor. We're going to come audit you. The first thing is panic. But is that typically where you come in, or you get introduced to most of your clients, is during that, where it's like, okay, cool. Well, if I get audited by the IRS, it's like, cool, here's the contact to my CPA. You talk to them, anything you need, that's who you go through. Does it work the same way with you?
It should.
Okay.
I wish it did. It should. If you get an audit letter, any of the, 5 people watching, right? Call an attorney, call me. Do that. That'd be important. What I see most often, though, is that the owner, the CFO, their HR person who may not have an HR background tries first. And then when that fails, or it's not going well, maybe they have a frustrated auditor, then they pick up the phone and they call. And typically, to your point of maybe a jack of all trades attorney, they call their general attorney, and the general attorney is probably like, this is a little bit too much for me. And then I get involved.
Yeah.
I would love if employers would be more proactive about it, right? And kind of do the self-audit first, pay the little bit of billable to have an attorney do it first. Because once the auditor gets involved, you potentially are talking fines and penalties, and you can't always get away from that. The other thing to note too is if you get an attorney involved early on, I would say well over 50% of the time, I'm able to get all the fines and penalties to go away, fix the problem, and then essentially that just paid for my legal fees. So it's really wise to get an attorney involved right away.
Well, I laugh because I do have friends of mine. They're like, who's your attorney? And I'm like, which one?
I say you shouldn't have your electrician doing your plumbing, right?
Exactly.
Same thing in the legal world.
And I think there's maybe a little bit of a stigma in construction too, that it's like, man, I really don't want to talk to an attorney. They're just going to click the clock and bill me for 15 minutes. But I have gotten to the maturity in my point to know that, no, I have an attorney for civil stuff. I have my tax attorney. Heck, I have one just for arbitration issues. Yep. And it's one of those where it's like, I love it because I have a bench of my point guards, my forwards, my centers, all of that. Sorry, I'm putting a plug because our Oklahoma City Thunder's in the playoffs right now. So, but that's super helpful. You mentioned something about fines, and I think this is a lot of things like that's not going to happen to us. But what are some of the fines you see come down the pipeline? Who do they come from? I'm sure that's the Department of Labor and government, but like, what's the size? What are the circumstances? Is to set a baseline example here?
Yeah, I mean, it could be as simple as just one employee filing a state wage claim, right? I'll use my state, for example. I sit in Wisconsin, and Wisconsin can be double damages. And so if you did something wrong, not only are you going to pay the employee back what you should have paid him in the first place, you might get double damages.
All because the state legislation says double.
Correct. Just because that's the state law, right? At a federal level, a lot of times you're looking at willful. And if it's willful or not, that'll kind of determine that. I have found a lot of times at a state level, there is less flexibility on wage claims. a lot more flexibility in other areas. I talked about worker misclassification. So a lot of times unemployment division gets involved. I've been able to negotiate those quite often because at the end of the day, the unemployment office really just wants their unemployment insurance money. Like that's what they want, right? The worker hasn't necessarily been wronged. Once you're talking about a worker being wronged, it's really hard to get out of the fines and penalties and the repayment. You have to make that employee whole, right? When you're talking about audits, that's where there are a lot more flexibility in saying, I didn't know doesn't work so well. If you're a business owner, you should know. They assume you should
You mean
know. I would
plead the 1, 2, 3, 4, 5th? That doesn't work.
Yeah. They're like, you're a business owner. You should miraculously know every single employment law, even though it's not related to your industry. Doesn't make logical sense, but that's what they'll say. But if it's not willful, ultimately, a lot of times you could be, you can negotiate them, but it does come down also to the relationship with the agency and the auditor. And so if there's no employee involved, it's not triggered by a particular actual violation. Usually, if you build good rapport, you're going to be able to work through some of the fines and penalties. They might not all go away, but you can usually work through them. Once a particular employee is involved or a group of employee and a class action's involved, that's where you're tacking on making the employee whole, fines and penalties, attorney's fees, right? Paying the other side. And for something that maybe you didn't even think you were doing wrong or you thought you were doing fair by the employee, you're spending a lot of money. And for your small construction business, it can put you under because they can be very costly.
Well, and we're going to dive into subs here in a little bit and contract labor. But before we do, my experience, like for example, we proactively invite OSHA and Department of Labor into our business to do safety audits. Do a program, we do it every 3 years. And it's kind of nice because they come in and they're like, they catch us on things, but it's like, hey, fix this. And it's not like a here's your fine type thing. But I have had several businesses in the past where OSHA popped up on a job site. They write up like, hey, here's what we found. These are the issues. Cease work until these are fixed. Here's your fines. And then I've been able to like proactively show them over the course of the next 60 days, hey, because of your visit, thank you. And sometimes, even though it is a government agency, politeness helps. But because of your visit or your citations, we have taken these actions. These are what we're doing. And they took those fines from here down to here. But what I'm hearing is on the labor side, it's not as flexible. It's not like a help me, I'm poor.
If it's an audit, yes. Like if you're just getting a normal standard, not triggered by a particular violation DOL audit, wage and hour, absolutely, right? My recommendation would be, as the auditor is giving you information, be making those changes as proactively as possible, right? Ask questions, seek to understand, build good rapport, and that will whittle the number down. They have a lot of discretion in what those fines look like because it's, again, not triggered by an actual employee violation against an employee. So it is similar in the sense to, I give the same recommendation to my clients from an OSHA perspective as I would if they got just a standard DOL wage and hour audit that wasn't triggered by an employee violation. As quickly as you can remedy and fix and show that you're doing something, it goes a really long way for fines.
No. Well, in the instance that there's a lawsuit, say from an employee, and they have representation, obviously that representation is going to represent their client for maximum returns based on their damages. And by the way, that makes it sound like we companies do no wrong. There's a lot of companies that do wrong. And, if there's an employee out there that needs, compensation for being screwed over on his paycheck, yeah, damn right. He should have it and a good attorney. But when the accusing party and the Department of Labor are on that side, not just doing a random audit, do you see less of that compromise from the Department of Labor? Like after a lawsuit is settled out, it's like, well, here's your fines. I mean, I'm sorry.
Yeah.
Get your crayons out for me, Tracy. There, because
I'll give an example, and it's kind of a mind blown. Construction company, seasonal. So normally in seasonal work, you're gonna have to lay off for a portion of the winter, right? They can't do work in the winter. This particular client decided they wanted to do right. It's really hard to keep workers in the seasonal business, right? And so they're like, we're gonna pay you 40 hours a week all year long. All year long, we're going to pay you. You don't have to worry about losing your benefits. You don't have to worry about having crap unemployment. Like, we are going to pay you all year long to essentially work 6 or 7 months out of the year, right? You don't have to worry about laid off. You just get to chill, take your vacations in your winter. And again, it benefits. That's a big thing too, right? Like, health benefits are maintained all year long. All the things that are positive. They had a disgruntled worker that didn't agree with that. They weren't laid off. They were terminated at some point for performance, I think, or something, right? Filed a wage claim because, of course, in the nice seasonal summer months, they were not getting overtime. But in the off months, they were getting 40 hours a week at their whole pay, not even a reduction, whole pay, right? Full audit happens. Former employees represented all the good stuff. When everyone crunched the numbers, the employees made more money on the client's method. Okay. The employees were financially and health benefit wise better off on the client's method. They still lost. And the fines and the penalties and all the things don't change because they were not properly calculating overtime. And so legally, those people should have been laid off and COBRA'd and gone on unemployment and all the things, right? So it doesn't even matter if the bad thing you're doing, and when I say bad, it's not really bad, right? But the illegal thing you're doing is actually better for the worker. It doesn't always play out that way in the legal system.
Well, let's get to knowingly illegal things. I mean, you know it, Tracy, subcontracting or contract labor is all over the construction industry. And it's weird because if you search this through AI and Google searches and, ChatGPT, Gemini, any of them, they all say something a little different.
They do.
So
Yes.
From your professional perspective, what defines somebody that easily fits in the contract labor bucket, 1099 sub, and people that clearly do not?
I really look at, is it something your business does normally, right? Is it a line of work that you typically do? Or are you bringing someone in, an expert, a specialist onto this particular project, or you're straying a little bit from the type of or the line of project you usually do and you're bringing somebody else in? Now, I will say, I always talk to my clients about what is your appetite for risk, right? Like, what is the likelihood of the subcontractor that's being 1099 and wants to be and is happy and likes it and kind of gray if they should be or shouldn't be? What is the likelihood of you getting in trouble? Probably pretty slim. But if you do, are you prepared that you truly did misclassify that worker? And now you aren't just looking at one area, you're looking at wage and hour. So you're looking at overtime, you're looking at minimum wage, you're looking at unemployment, you're looking at work comp, you're looking at so many different areas that you don't have this little legal exposure. So for me, my job is to educate my clients, right? If they're okay taking that level of risk, and the interesting part is someone might be able to be classified as an independent contractor, a sub, in one area of employment law, but not another. So maybe for purposes of taxes, payroll taxes, right? So maybe for those purposes, they can be under state law or federal law, but can't be for unemployment or work comp or overtime. And so now you're like, which one do I pick? Right? Like, how do you decide that? And to me, that again is just your appetite for risk. But it is becoming a large area of focus both at a federal level and a state level. So I don't see it getting any easier to classify workers. I only see it getting harder.
Well, and that's how we met. You essentially were doing a voluntary run through an audit with a company to assess risk,
Yes.
right? And if somebody wants to do that, how do they reach you for that, by the way?
Email me, call me. I don't know if you put the information out to the group.
We put your direct cell phone number in the notes and said call between 12 a.m. and 3 a.m. in the call.
Ooh.
I'm kidding. We didn't do that. We,
Don't get my voicemail. I'll call them back.
yeah. Or they get you on an early morning with not even first cup of joe in.
Right. Yeah. I think that my goal and how my practice primarily operates is proactive. I do find that once a business owner dabbles in the proactive piece, they become really, really happy because they know they've reduced that level of risk. They know they're not, if an audit comes, because it could, they're going to pass flying colors, right? And so when you're a business owner, any of the uncertain expenses are the things that keep you up at night. Those things that I don't know. I can't wrap my head. I know my fixed costs. I know my payroll costs. I know my operating costs. I know my product costs, but those uncertain costs are the ones that keep you up. And if I can help give a business owner peace of mind there, the couple grand somebody spent on an audit prep is definitely worth it to know you're not going to get in a pickle later.
Yeah, comparative to in your state, double damages.
Yeah,
This
I know.
Just because we live in this state, it's double. You pass go, you collect just
Right.
because of the state you live in. But, I want to go back to this because we see a lot of this with subs. And good Lord, just go through any Facebook group, whether or not it's foundation repair, fencing, electricians, any trade organization group. And there's a lot of people that are like, well, I just sub it out, and they're dictating time or schedules, or you have to put a yard sign out, like weird
Or you have
things.
to wear their attire, show up at the door.
Well, that's
in
what
their
I was going to
clothing.
ask. Like, what are like big red flags? It's like, yeah, you're not subbing. You technically have a full-time employee.
I mean, the easiest one that I think can make or break it is this person doing work for anyone else? If this person is doing work for no one but you and they're working for you 40 plus hours a week, it's probably going to be hard to check the other boxes.
All right, tradies, I know lead generation has been top of mind for all of us this last year and going into 2026. So let me put you onto a marketing team I actually trust, Greenbaum Steyer's Strategic Marketing Group. And oh yeah, they're friends and network affiliate of ours, but I'm telling you straight, these guys are different. Most marketing agents, they've never worn boots. They never dealt with seasonality, weird leads, price shoppers, no shows. Mrs. Johnson calling you back 3 times because her basement feels wet. Greenbaum Steyer's was literally born out of a successful foundation repair and waterproofing company like mine, so they actually understand how our businesses work. They've been doing this since 2017. They're a full-service branding website. They convert with SEO, compounding over time, traditional media buying, and of course, lead generation that makes the phone ring. But the big thing is strategy. They're focused on helping you overcome what's holding you back, tighten up your systems, and hit real goals, profitable goals, and not just some vanity metrics and pretty reports that you can brag about at some conference. So if you're tired of guessing, tired of wasting money, and you want a team that knows contractors and knows how to drive results, go check out Greenbaum Steyer's Strategic Marketing Group. Tell them Will and Terry sent you. Their website's greenbaumsteyers.com. That's GREENBAUMSTIERS.com. I'll put it in the link. Keep grinding out there, tradies. Well, and this is where there's blurry lines. The law is not the blurry line. It's noise on the internet that says, well, if they're doing 80% of their work for you, then technically they're not a subcontractor, right? But I don't know if that's true or not. I mean, what's your opinion?
Not. It's the unfortunate part is the federal law changes all the time, so that's fun.
Mhm.
The state law, every state's different. So now you're talking, let's say, a multi-state employer, right, with subs all over
Yep.
the U.S. You've got to look at, well, maybe you can have that sub in Nebraska, but you can't in Texas, or maybe you can have it in Florida, but you can't in California. So then how do you manage your workforce if some people doing exactly the same thing, some are 1099s, some are actual employees? Super confusing for people. How do you hand a handbook and expectations to some of your workers, but not others? Right? How do you pay them differently? How they negotiate things. Now, if you want to bring everyone together to try to have some camaraderie, some sort of, annual holiday party or whatever, what does that look like? Some are employees, some are not. So it's challenging. If you're a one state employer, definitely easier because you can just look at your state law. You can determine whether your workers are or aren't. And if you're close to on the edge, maybe you have to make a couple changes, right? Maybe they get some more flexibility. Again, I'll use my state. My state is super hard to have an independent contractor in. They have to like call themselves out to be their own business. I had a client that had an audit. It started as an unemployment audit, moved to wage, but they literally scrolled through Facebook and social media. And if the workers did not identify themselves as being independently in business, and or if they listed my client's name as being associated with like kind of as their primary place of work, automatically failed.
Yeah, kind of like start a new job at X Acme company. That's crazy.
It's like you're not an independent contractor because now you just identified yourself as working there.
Yeah. Well, and by the way, for those listening in to Tracy, because now I'm totally not sticking to my format of questions. You know, there's this concept of subs, then we're going to go through piece rate, then we're going to go through actually full-time employment and this movement, because you mentioned it a few times, and we're going to nail down this issue of discretionary bonus, non-discretionary bonus, and how it affects overtime. But before we get there, I think it's important to understand who's a sub, right? And then there's this in between subs and full-time employees where, gosh, I think Frederick Winslow Taylor, I remembered it, ADHD moment. The king of piece rate back in the 1800s said, this is how we're going to pay per unit. And then there's a mixture of companies that are like, well, we're just going to pay piece rate. And what are the red flags there? Because it's widespread in construction. I know it comes across your table. So somebody exploring piece rate, considering it, like, what are the big red flags that immediately in your seat, like, whoa, have you checked these boxes?
So I have one client that does quite a bit of piece rate, actually. You know, window and door companies, finish work is pretty common piece rate. And so you might have like your installer, your sales, all those people, they're employees, right? But finish work is very specialized. They actually like to do piece rate because heck, I can get all my beautiful staining and finish work done and I can go home after 4 hours or 5 hours, right? When I have a client that says they hold people to kind of a standard of hours, and a lot of extra work that goes into things. I'll use my window client doesn't actually do it, but let's say they did make the finishers that are piece rate. They also had to unload the product off the truck. Then they had to load the finished product back on the truck. Plus they had to work specifically from 7 to 3, no matter what, if there was product available to do the finish work on or not, right? That would be a red flag, because now how are you going to be able to say, because you have to show that the amount you're paying for piecework is going to be able to meet your minimum wage and your overtime and all your requirements. And so if I only got 1 or 2 things done today, my piece rate, my wages are really, really low. You made me work 8 or 9 hours because I was doing all these other things that you added to my to-do list. You probably are not going to meet minimum wage and overtime standards.
Yeah. Well, and it's funny you mentioned that, because I think we had this conversation months ago. And during that conversation, I was like, I got to get you on my podcast. Finally, 3 months later, we had it happen. Where like, it's like, okay, cool. I just tie this up in my employment agreement or handbook that the employee signs. And you're like, yeah, it may work for your state, but it doesn't protect on the federal level. So it's a two-way street, and you've mentioned a lot about state levels having quite a bit of control. But tying that into an employment agreement, does that really, I mean, is it paper thin at that point? It's not a question of if, it's when it's going to bite you in the ass.
I mean, employment agreements are great, right? I will tell every employer documents are great, whether it's employment agreements, handbook, policies, commission agreements, they're all great, but they're only as great as they are if they're legal, right? Your employee can't agree to something illegal. It's still going to then be called into question, and it's not going to be upheld. And I think that does even...
That's actually a great, sorry to freeze you at the foul line there, Tracy. an employee can't sign anything illegal, but most of us don't even know that we're pushing across the desk something illegal in the first place. So it's like,
Yeah.
it's such a fucking catch-22. It's like, wait a minute, whoa. So then that makes the employee de facto the victim. Is what
Correct.
you're
Because if
saying.
you look at bargaining power, right? You and I own a business, right? If
Mhm.
we're bargaining, the court's going to say we have equal bargaining power. And so we can agree to certain things, right?
Mhm.
Because we're at the same bargaining power, same level. Courts take a very hard stance that the employer is above the employee from a bargaining level. The employee should not be required to have the same knowledge as the employer when they're bargaining for these things. I always laugh when I get an email from a client, and it probably happens at least once a week. Can you hand me a standard employment agreement? Can you hand me a standard 1099 agreement?
Mhm.
There is not a standard. What state are you in? What industry are you in? What are you trying to do with this particular relationship? So using just boilerplate, AI is a beautiful thing, by the way. I'm not going to say it's not. It is a beautiful thing. It has made my job easier in so many ways. I'm sure yours as well, right? But AIing and having it create you an employment agreement would be a big, I would urge you not to do that.
Well, and it's funny, I had that on one of our questions today, but I realized it's like, that's just probably short form clickbait. But I have found that there's a lot of misleading data pulls from large language models or AI around the details subjective to the state and what you're doing and your bonus structure or incentive structure. It's giving you what you want to hear, not exactly what you need to hear, not want to hear. And I don't know if you would agree with that, but I'm seeing that a lot with AI about like performance pay, piece rate, all of that.
Yeah. I mean, is it right sometimes? Yeah, it is. But
The
I
key is
have,
sometimes like, how much do you want to de-risk?
I know. Well, and I have the perk of if I have AI whip out a document or a clause or something, I can check the legality of it, right? Because that's
Yep.
my background. The average business owner, that's not their background, right? So even, anything in the employment space, if you are going to have AI create it for you, still run it past an attorney.
Yeah. Well, by the way, we're going to take a little side quest here, Tracy.
Okay. I'm ready, maybe.
And I'm actually curious about this. So before we get into the last end of the spectrum, we went from subcontractors to piece rate to now employees. And before we get into that, I like to because we as employers, we want to give bonuses and things like that. So before we get into that, I love this use case study of Ruth Ginsburg, big on, the civil rights movement for women and all sorts of things, right? Well, I live in Oklahoma, and funny thing is she championed a case that got pushed up to federal court, and men listened to this. So there was a discrimination case brought to the federal level, and men were discriminating or filing that because women could buy Coors Light in Oklahoma at age 18 and men had to wait till 21, that it was sexually discriminating to men. And thus, that pushed up the Supreme Court and became an issue with sexual discrimination.
Reverse discrimination.
Yeah, and funny story. You guys, you screwed it up for us, right? All because you wanted beer. Coors Light, specifically. I'm drinking Yingling today, but the case study is some case dictates future settlements and standards, right? So these horror stories you're talking about, a client, lost to this employee and their attorney, like that, is that in the book of law essentially setting standards in each state moving forward?
No, I mean, law's interesting. Are there certain things that are absolutely black and white? Like you can't pay anybody less than the federal or state minimum wage. Black and white, right? You don't need case law
Yeah.
to tell you that. Other things are going to be case law driven. And so while this is going to definitely go outside of wage and hour, but still in employment, we know that the FMLA grants up to 12 weeks of leave, black and white. We also know that the ADA grants some amount of accommodated leave as reasonable. But how much? 1 week, 2 week, 4 week, 12 week? I don't know, right? So that's when the law doesn't say. It just says some amount of leave is reasonable under the ADA. Now we're going to look to case law. So we're going to see what have courts been saying. And that's going to be in different jurisdictions. It's going to say different stuff. And when we talk independent contractors, that's why we have a very vanilla federal law. And then we see that we have some states that are going to have very specific, maybe an ABC test, maybe a 20-point test. The IRS has a test, right? But then we're going to have other states that are going to say, we don't have a test, but we've had judges say this and this and this. So employers, you probably want to do this because if you're in front of our court system, they're likely going to go back and look at what the last judge says. And absent unusual circumstances, they're going to side the same.
Yeah. That's why I appreciate what you're saying, Tracy, because risk is not absent in any of this. It's amount of how much are you willing to expose risk. And that's where we move into this last column. Most home services companies, they have W-2 employees. They want to give those employees some type of reward. Call it the carrot and stick, call it whatever, call it performance bonus, call it a spiff, whatever. And it's genuinely out of the goodness of our heart.
Yeah.
And sometimes it's totally just smacking us upside the head. So what are the biggest mistakes that you're seeing? And actually, before we get into that end of the spectrum, could you define for us what the law views discretionary versus non-discretionary bonuses or incentives?
See, it's a good thing I kind of know my stuff because that was not. There was no prep, but I figured you were going to go there.
You're probably looking at that document I sent you. You're like, where the hell is this guy? He's not.
Which is okay. So we have non-discretionary and we have discretionary. So a non-discretionary bonus is something that you've told your employees they're going to get. It is something related to number of installs per week, something related to if you produce this much, you're going to get a bonus. If you have a customer satisfaction, right? You think in the service industry, HVAC, some sort of install company, there's going to be some sort of customer satisfaction. Your customer satisfaction number is a 4.5 out of 5, and you have some sort of bonus attribute to that, right?
Yeah, and I got to stop you right there, Tracy. That is massive because I have done this for years. You shined a light on this for me in one of our previous meetings. We walk in, it's about to be a new month, and it's like, guys, we have a contest. If you hit this number, and you get $100. That makes it non-discretionary. You have set a clear boundary. And we do that all the time.
All the time. And you want to do it because that's how you motivate your workers, you get satisfied customers, you get good quality on the job site. Like logic is there, but you don't then do the right thing with that bonus when you're calculating pay. But what you said about the $100, right? And I think I used the example earlier about the clean cars, right? Who wants all their work paid for vehicles to be gross at the end of the week coming from construction sites? Now, if you have nothing written, you don't tell anyone anything, no one even knows it's coming, and you just are like, oh my gosh, Johnny has the cleanest car and it's always coming in and I never have any repair issues because he's so good about this. And you toss him $200 on his next check. Totally discretionary. Johnny didn't see it coming. The next guy that has a clean truck may not get it. It's definitely discretionary. The employer has 100% control whether to give it or not give it. It's not planned. It is not written in some sort of bonus program or commission program. The employee has no expectation to get it. The employer just said, good job, Johnny. I want to reward you. Now that is $200 on its own. Don't give it in cash, please, because that's not good.
I was gonna ask. I was like, man, I got no. I've already got
'Cause
these
now we have
people
some
thinking
tax
like we're
issues.
gonna give that cold hard monopoly money. Let's give it out. Yeah.
Don't do it in a gift card. No, we have some
There's
tax
the next
issues.
one. Damn it, Tracy, you're
Yep,
two
yep.
steps ahead.
That's the IRS. So that's a totally
Yep.
other area, but it enters employment a lot. But that's discretionary, But most of the bonuses in this industry tend to be non-discretionary.
Mm-hmm. So that's where, when we talk about non-discretionary, you're right. Most of it fits in that column. Well, I could say this out loud to, our handful of listeners out there. Like, most of us owners are ADHD anyway, and they're like, man, you killed it. Here's $100. Yeah. On the discretionary, is that viewed the same in the form of non-monetary bonuses? Like, here's the gas card, go fill it out or fill up your car, or here's, you used gift card before.
Yep.
Or I'm going to buy you a TV. Like, did those things apply?
So they're discretionary, right? Unless you have some sort of program where you're planning to give workers TVs, right? So
Yeah,
that
and
would be
this is
different.
where it gets interesting and why I bring it up.
Yeah.
Because when it becomes discretionary, it still is going to relate to this overtime issue later. And we're building this up.
It's not going to relate to overtime. So when it's discretionary, you're not going to have to worry about it being calculated in your regular rate and worried about your overtime issues. But what you are going to have to worry about is, how are you paying it to them, giving it to them? And is there a tax obligation on that? And so that's where the IRS comes in and says there are only certain things that are not taxed as it relates to what you give your employees. So it's not necessarily a wage and hour employment issue. It's a wage and hour tax issue.
That's where
they do provide a really nice guide, though. Plug for the IRS. They make a beautiful guide that talks about what you can and cannot give and when it has to be taxed.
Tradies, running your small business can be demanding. You got suppliers you got to work with. You're managing crews. Hell, you're chasing sales. It's a lot to take in. Listen, if you want to grow your business, you got to stop working in it and you got to start working on it. So that's where my friends at Foundation Rescue Supply come in. You're not just getting foundation repair products and waterproofing products and air quality control products. With their nationwide distribution, you're getting a partner who knows how to help you scale. And that's why I use them. The Foundation Rescue Supply team has industry knowledge that'll help make your life easier. You get the tools, the trainings, the systems that you need to move the needle. You want your sales team to close more leads? Done, because they have the proven process for that. You need your crews to work smarter, not harder? Done. Their installation training will get you out there and rocking and rolling in the field. With Foundation Rescue Supply, you're not just buying materials here. You're buying a better business system that they have helped create. And you sell more, you install more, and you grow your team. So the bottom line is this: you get best industry pricing, you get field productivity on track, and you get more revenue out of everybody on your team. So this is your chance to step up, scale up, and thrive. If you are ready to make that happen, head to foundationrescuesupply.com, check out their catalog, and speak to my friends, their team, how you can take beyond the products with your company with Foundation Rescue Supply. Yeah, so for all of you out there promising steak dinners and inappropriate gentleman clubs trips, you know who you are. Watch out. But now, you had mentioned it 3 or 4 times, but I think it's good to go through the evolution before we mention it. The big red blemish on all of this is overtime. And describe to our listeners like why this is such a red flag. And by the way, maybe we make a whole other segment where we actually get like a whiteboard out, because it's complex.
It is so complex.
But it's such a growing problem. And you mentioned Illinois before. California, we know they've been crazy for a while around this. But there's other states like filing suit. And we know this, that when there's so many states, it eventually reaches an apex and all states adopt it. And not only Illinois, I know New York is right behind them. Canada's already taken on some of this stuff. But break that down for us and why the overtime is such a risky side for this, Tracy, and why we should be taking note.
Overtime's a big deal. I want to touch on one littler, but maybe it's bigger than I even know it is. It's the hours that employee is working that may not be recorded. So think about getting all the tools ready to get on the vehicle, the travel time. So it does all lead into the overtime equation, but to calculate overtime properly, one, you have to know all the actual hours worked. And in this particular industry, a lot of hours go missed because workers are not like going right into an office at 8 o'clock and leaving at 5 where you're watching them, they're punching a clock, right? So the first step is to truly understand, what are your workers working and are you paying for all the hours you should be? The second step is, are you including all the various types of pay into that rate? And so that's where your discretionary, your commission, all of the different, your piece rates, all the things that need to be included, right? And then that is really whether or not your overtime is calculated correctly. Because if you don't have all the right hours, and if you don't include all the correct forms of pay in the regular rate, there's no way you'll have your overtime rate right. It's not possible.
Yeah.
And it is super confusing. And that's where, plug for Will, if you need systems, if you need things, right? Like finding a resource that can help you calculate is really, really important.
Don't give me credit, because it's even muddier, because at the end of the day, it's all systematic around many times. You started this conversation, this entire podcast, with most people want to do well. They just don't know that they're doing it illegal.
Yeah.
So it's like, all right, if you get an employee and they did 45 hours, their normal rate of pay is 20. Well, at the end of the week, before you do overtime, go ahead and add that $10 gift card that you gave them for hitting that contest, and the $20 or $25 piece rate bonus, and, hey, perfect attendance bonus on the paycheck. Well, now all of that accumulated now rolls over and is adjusting the base rate. You think you're paying them X amount, but now because of all that, you're not paying them X amount in hourly rate. You're paying them now in an adjusted rate. So every overtime hour is 70% more than what you thought. And that's where
it depends on what's all going into that calculation. And honestly, I wish the government would call it something else. Regular rate. If I hire someone, I say your regular rate is going to be $25 an hour, right? And then you think 1.5 times that is overtime. Boom, done. Regular rate has a very different meaning when we're talking about how to calculate rate of pay and overtime for FLSA purposes. So it's a terminology issue, I think.
Well, I was going to ask you that. I hear regular rate of pay, premium rate, premium overtime, weighted overtime. These are words I hear, and I'm like, what are the standard definitions that should be equalized in this conversation?
Really, regular rate and overtime. Because in your regular rate, your shift differential, if you have you have an hourly plus a piece rate, plus a commission, plus a bonus, all of that is going into what is the definition of regular rate. That one definition is going to then allow you to calculate your overtime rate, which is 1.5 times your regular rate. Once we're talking shift differential or all these other things, those are usually almost all the time things that are going to get lumped into your regular rate. They themselves are not the separate and distinct thing, unless we're talking these discretionary bonuses, right? Which you get to remove those. So really what you're looking at as an employer is, out of all the compensation I give this worker, what goes into the regular rate and what, according to the law, can I pull out, right? Your discretionary. All the other stuff is just random terms, maybe, right? They're not
they're trade terms that kind of
separate.
stuck. Yeah. And, Amanda, that was our bookkeeper and accountant 3 decades ago, that's no longer here. All of a sudden, that's the term she used, and now we've adopted it. So, well, and I think this is important also to know, because the waterfall effect starts to kick in. And as we're paying these out more and more as employers, if we're not adjusting it correctly, that unadjusted amount that we haven't been paying is just building into this account, waiting for the audit.
Yep.
And all we want
I
to do
know-
is pay our people more.
I have clients that are like, well, but I'm not going to have any overtime for my workers. So it doesn't matter because it won't matter.
Yeah, that's.
But then what do you do once they have overtime?
Like, that's the number one thing employees want in the field services industry. It's like, yeah, we want that OT. Well, and that's another interesting thing. And I know we're going long here. Like, you helped me clear up a blurry line where it's like, okay, you have a field team, they're going out, they're installing a project. If they install 100 feet of fence, 6 hours less than what was budgeted, they get a bonus. Now it's discretionary, right? But they upsold something on the site. So no, that commission essentially is folded into that whole thing because you've now dictated it for the field service groups. And this is widespread in HVAC. And I think it's a growing problem in certain specialty trades that I was naive to be clear, like, oh yeah, it's a sales commission. Boom. Well, no, you just dictated outside of the normal hourly and overtime rate of pay what the circumstances are. And I'm like,
and I think it's it's employers combining multiple buckets, right? There is a sales commission rule. And absolutely, there is not overtime associated with it. I've told you this, right? My husband, he does sell windows. So when I say my whole family, I did also marry into it. So my husband sells windows and he's 100% commission. He can be under the law. It's fine. But when you're saying you have an hourly installer, they're an hourly installer. They might be eligible for a portion of commission if they upsell, but they did not meet the sales requirements to be in the commission sales exemption, right? And so it is very often that those two areas are combined together to like pick the best of both worlds, right?
Yeah. Well, and I tell you, that's where your knowledge really shines, Tracy. It's just like, I got all you guys fooled out there watching. It's like, oh, Will knows his shit. He's got his shit together. And then I meet Tracy and I'm like, I don't have a clue.
You do have your stuff together.
But it's one of those where it's like, oh, damn, this is a multi-layered problem. And we all want to scale. We all want to grow. We want to grow profits. We have to do that through our people and our value proposition and how we sell our products and services. And then all of a sudden, bam, all your returns got wiped out because you got audited or something like that. And I know you're out there that you lose sleep on this stuff, contractors, and then all of a sudden you get that letter in the mail and it just, it ruins so much more than just business. It ruins your personal life, everything. So Tracy, I can't thank you enough for being on. And gosh, I could go on for a whole other episode on this. I think we should probably do just like a 6-month weekly or 6-month biannual update on just like what's the landscaping looking like because it's changing. So we obviously will put you down in the show notes, but just so we can hear it one more time, what's the best way to get a hold of you?
You can email me, Melvin at melvinlawoffices.com. Will, thank you so much for having me. It's been great. I love doing these things proactively. I would love to make sure I help employers do the right thing before the audit comes or before the lawsuit comes. So I really am so appreciative to be on.
Yeah. Well, Tracy, I appreciate you and thanks for being just a good human being for us in the trades too. And then to you guys out there, listen, seriously, click these show notes down here and just know that Terry will be back next week. I know you guys miss him, but we'll see another episode next week with Beers with Contractors. See you guys. Peace.
And that's a wrap for today's episode of Beers with Contractors. We hope you enjoyed our chat as much as we did. Before we say our final goodbyes, a friendly reminder. Beers with Contractors encourages responsible drinking. If you choose to enjoy a beverage during our time together, please do so in moderation and only if you're of legal drinking age in your country or state. Furthermore, the advice and insights shared in this podcast are for informational purposes only. Always consult with professionals and experts in your field, and be sure to follow local laws and regulations regarding licensing and permits. We're here to help, entertain, and inspire, but your safety and compliance are important. So, as you head out into the world of construction and contracting, remember to build responsibly and make decisions that stand the test of time. Thanks for joining us today. We'll catch you on the next episode of Beers with Contractors. Until then, cheers to your success.